You're listening to Systemic Error Podcast. The failure was designed.
Federal court thrashes red state's breathtaking attempt to ban unpopular ideas, based on an article by Nicole Charky-Chami. Florida tried to turn professors into state mouthpieces. The state tried to own the lecture hall. Florida passed a law aimed at public university classrooms, not to improve education, but to police what professors could say about race, sex, and privilege. The 11th Circuit just struck it down, and it did so for the obvious reason. The state was trying to control viewpoints it disliked and dress the move up as policy. This is not a small technical dispute. It is an attempt by government power to reach directly into the classroom and decide which ideas may be voiced by the people hired to teach. The real power was never hidden. The institutional power here sat with Florida's state government, which wrote the law and tried to enforce it across the public university system. Professors were the target, not the actors. Students were the pretext. The law's real function was control. That matters because the story is not about a misunderstanding between equals. One side had the authority to make rules for public institutions. The other side had speech rights the state was trying to shrink. The imbalance is the point. Misdirection in legal clothing. Florida's defense, as the court described it, was a familiar trick. Because the state pays professors' salaries, their speech must somehow belong to the state. That is not a legal theory so much as a power fantasy. It treats public employment as intellectual ownership. The court saw through it. Judge Burt Grant's opinion rejected the idea that Florida could evade First Amendment limits by relabeling viewpoint discrimination as government speech. That is the core scam in so many censorship efforts. Take an act of suppression, wrap it in administrative language, and hope nobody notices the difference. The target was academic independence. The banned concepts listed in the law were the point, not the pros. The state was not merely setting classroom standards. It was drawing ideological boundaries around which ideas could be endorsed and which had to be treated as forbidden. That is a direct attack on university autonomy. Public higher education is supposed to be a place where ideas are examined, challenged, and defended. Florida instead tried to make professors into regulated transmitters of the state line. The court's language about puppeteering is blunt because the conduct deserved bluntness. The court named the trick. The decision matters not because it was elegant, but because it cut through the laundering. The law did not collapse under ambiguity. It collapsed because the state's theory was too naked. If Florida can control which viewpoints its professors may endorse, then the First Amendment is reduced to a decorative phrase. That is why the opinion's language lands so hard. The state was not advancing neutrality. It was engineering obedience and calling it governance. The pattern is bigger than Florida. This is the same authoritarian habit in a local costume. Sees institutional power, rebrands censorship as common sense, and insists that the target is free to speak so long as it speaks only within approved limits. The limits are the message. The deeper political lesson is simple. When state power tries to discipline universities, it is not protecting students from bias. It is trying to turn public education into an instrument of political control. Florida lost this round. The impulse behind the law is still doing what it was designed to do, testing how far elected officials can push before courts force them back. You've been listening to Systemic Error. Thanks to Raw Story for today's article, with the automated voice of Joe. Thanks for listening.